So this video lecture is a very short discussion of liability in student records. Legal challenges involving defamation have become increasingly important, and there are a host of issues that involve something called the Family Rights and Privacy Act, or FERPA, that must be understood and addressed by all school personnel. Significant violations of FERPA by school personnel and administrators may result in the loss of federal funding. The rights of parents, eligible students, non-custodial parents, and school personnel are all really increasingly under the microscope as school administrators deal with some of these challenges. Much of these things are associated with the word defamation. Defamation falls into two categories: libel and slander. Libel is written defamation, while slander is oral defamation. Both contain statements or communications that result in injury to a person's reputation, good name, or standing in the community. The burden of proof resides with the person who brings charges of libel or slander to demonstrate that injury resulted from the alleged conduct. Certain statements may be made upon their face and may cause injury to another based on the content of their statements. The person affected by these statements need not prove damages when statements are made regarding criminal behavior, professional or job competency, possession of a contagious disease, or other issues. And so this involves school personnel, mostly because of the notion that school personnel are talking to students, interacting with students, and keeping records about students. And so this opens the door for this type of defamation to potentially occur. And so student records and the access to student records by parents represent a primary source of this conflict. And parents sometimes will insist on inspecting records of their children, and school districts many times oppose such inspection. So much of the conflict involves access to records that are attributed to issues around FERPA. And we're going to talk about a case, but one particular aspect of FERPA that does come up a lot for administrators is this idea of directory information, because not always will parents want information from schools, but the media will also often want information from schools. If students are involved in athletic activities, there are details about that student that might be released and published in media. The same thing would occur if students are in automobile accidents or injured or even killed. And that doesn't sometimes have anything to do with the school. Schools are permitted to give directory information to the media that are part of the students' records, but they are permissible to be released as directory information. That includes their name, their address, their phone numbers, any degrees or honors, their field of study or major, if you're talking about a secondary or post-secondary school, their dates of attendance, and of course, in dealing with athletes, you may also release their height and their weight. Otherwise, any information then would be considered privileged and protected by FERPA. One of the cases that we'll talk about when dealing with this privilege is this notion of school districts involving parent access to these records. And so in Illinois school districts, in the case Garlic v. Oak Park, an Illinois district violated the state School Records Act by refusing to turn over a student's biology test booklet, and her parent requested a copy. The superintendent indicated that the information was not covered by the School Records Act, and that since test booklets contain no personally identifying information regarding the student, while the biology booklet lawsuit was pending, a parent made a new written request to the superintendent for copies of their daughter's algebra exams. Instead, the parent was offered the opportunity to examine test booklets and copy of test questions on school property or at home with a stipulation that they need to be returned. He was allowed to hand copy the test questions. The parent sued the school district and the state court system seeking a declaration that the booklet was a student record under the Records Act. The state trial court held the booklet did not fall under the act and were devoid of any student marks or other information. The appellate court in Illinois affirmed that judgment. The student's name, answers, calculations were not contained on either of the booklets. On appeal, the court stated that the overall intent of the act is to permit a broad right of parental access to records. The court agreed that the algebra booklets were covered by the act. While the questions themselves had no information concerning the student, they were part of a document containing such information, and the entire test booklet with her markings fell under the act. When student markings or other identifying information could be found on test booklets, they become student records subject to parental rights, inspection, and copy. The district did not comply with the act by allowing the parent to take the booklets home, and the court reversed the decision. Similar things have come up in college with regarding tests and students' complaints seeking opportunities for more information about grading. Generally, the same standards apply, and they must, release that information if it's a student record. Student records may be digitized in today's world. There have been some cases and some concerns that digitizing conflicts with FERPA, but digitizing these records does not conflict with FERPA. This electronic technology is sometimes subject to intrusion, and that's where you get into the need to take the necessary steps to protect the privacy rights of students' personal information within your computer systems, and have insurance and all those things, have properly trained and authorized personnel that access them, and contingency plans that ensure that these things can be accessed in the digitization process. Talk about the notion of privilege. On a number of occasions, school personnel are requested to provide oral or written information on a student. And when these requests are made, the school personnel typically respond in a truthful, professional manner in accordance with their prescribed duties. When they do that, they are protected by qualified privilege. When the recipient and school personnel provide the requested information, they have a common interest. They are protected by a qualified privilege, and this privilege is lost if the communication is transmitted to another person who does not share this common interest and has no need to privilege this information. This is where a lot of teachers run into difficulties in sharing information out and about in the community. And so that's why it's an area for principals to obviously do some work with staff and training. Qualified privilege is based on the premise that the educator is operating in good faith when sensitive information is communicated to another person who has an interest in receiving the information. Good faith requires that a legitimate purpose be served by communicating the information. Further information should not be communicated with malice or intent to harm the persons about whom the information is shared. An absence of good faith in communicating information may result in personal damages brought against those who do not operate in a reasonable and prudent manner. An example of good faith is illustrated in several different cases that involve students, one that we're going to talk about here in a moment. But also want to say something about a level of confidentiality that is needed between school counselors and students. And the success of the counseling relationship is really built on, in large measure, a feeling of trust and assurance that confidentiality will not be breached. Generally, the confidential relationship among counselors and students is recognized and respected. However, counselors have a duty to warn during counseling sessions where a student is clearly expressed an intent to inflict bodily harm on an identifiable person. Could be them or could be someone else. Failure to properly warn another individual of potentially harming behavior may result in liability for the counselor and should the individual be harmed by the assailant. In this instance, confidentiality is outweighed by the consideration of public safety. You have this a lot in school safety related issues today. The Tarasoff versus the Regents of the University of California case is one case that confidentiality between counselors and students is illustrated. And of course, this is a psychologist during a therapy session said he was going to kill another student, and he was subsequently killed by the student. Her parents filed suit claiming that the psychologist had a duty to inform campus police and warn their daughter of this impending danger, and the court agreed. So it's really important in the counseling office that this be upheld. Talking about acts of malice versus truth, these are really significant concepts, legal concepts when it comes to defamation cases. Malice is present when there is an intent to harm or injure another person. The intent is a critical element in cases that involve defamation. A tort occurs when communication is made with the intent to harm or injure. A tort is a violation of law to injure another person. It becomes more evident if information is communicated is proven to be false. Statements must be free of malice and avoid allegations of defamation. When evidence demonstrates that school personnel acted in bad faith with the intent to injure another person, liability charges are generally justified, even if the statements are true. All persons are entitled to liberty right with respect to the expectation that their reputation be protected against unwarranted attacks. Very big issue in social media even today. There are essentially two types of malice: implied malice, which the offender has no defense for conveying harmful information, and actual malice, in which a person harmed must demonstrate the offender had a personal motive for doing so, and that this motive was calculated to generate ill will against the offended person. The Falvo Owasso Independent School District case is a good case that illustrates this. It's a case involving a challenge by a parent who brought suit against a school district for grading practice that she alleged created a severe embarrassment for her children. Some of the teachers in the district allowed students to grade each other's work, assignments, and tests and call out their grades to the teacher. Falvo was informed that her children had the option of confidentiality, reporting their grades to the teacher rather than calling them out in the class. The district court dismissed the suit. On appeal to the circuit court, however, they recognized the existence of a 14th Amendment right to prevent disclosure of certain types of information. However, schoolwork did not rise to that level. With respect to FERPA, however, the Court of Appeals found that the grading practices did violate FERPA guidelines. The court ruled on behalf of the parent because the practice of allowing students to grade papers is not prudent. Teachers have a part of their professional responsibility and duty to do the grading. At best, this practice is questionable and may be a source of embarrassment to students. Any practice involving disclosures of students' grades to unauthorized individuals violates FERPA and should not be authorized by school districts. Truth is generally considered a defense to charges involving defamation. If a person making the statement is doing so based on information believed to be accurate and reasonable, courts will generally recognize these statements as being non-defamatory in nature. The inference here is that communication must be transmitted with good motives. However, statements that are true will not be supported as a defense if there is evidence of malice. And this is very tricky to work through. But basically, school personnel are vulnerable to defamation charges based on sensitive information they encounter in their daily work. And this is important to understand. School personnel are protected by qualified privilege when statements are made in good faith without malice. There is some degree of disagreement among the courts as to whether teachers are considered public officials, but generally speaking, truth isn't always a defense. You have to prove malice. And so that proving malice for a public official rises to a different level. But it's really important, particularly as a leader in a school working with staff, to understand the importance of school records, but also how you talk about students and who you talk about students to, based on your need to have qualified privilege and making those statements in good faith. So a lot to think about for future school leaders.